Yes, so for those who have joined the call for the first time, the purpose of this meeting is to decide on court requirements and oath for the jurors and an oath for the magistrate, and then to select members of the jury. We've been putting this off for several meetings because a group from California wanted to review it and give their input, and then they pretty much abandoned post. Haven't come back, so what we're going to do today, if somebody can check that chat note, somebody's got a chat note. We're going to start with the oath for the juror. People who are on my phone and not my computer, you're going to have to just listen to me read it. Unless you have a really smart phone that can let you see it. But the juror's oath starts with obviously juror's oath. I, and you give your name, give oath that I will, actually stop, pause, I'm getting ahead of myself. We have to have the minutes from last meeting. Joshua, can you bring those up and blow it up so I'll be able to read it?
I gotta find my name.
That's fine, take your time. Okay, so the minutes from the last meeting, let me pull up the calendar, see the date. It was April the 16th, I believe, 3 weeks ago, and a day. We had very few people that said they were going to show up, and had some new people, and so we made a motion to table everything for 3 weeks and a day to today, and which we have adjourned. We then adjourned, and now we have convened again today. So with that said, is there any variation with the minutes? As everybody that was present recalls it. So with that said, is there a motion to accept the minutes as read? Here. Joshua Hollenbeck makes a motion to accept the minutes as read. Is there a second?
Second.
And folks that are online can do it just simply by raising their hand or speaking up. Was there a second?
Second. Yeah.
Okay, Jenny Mixer seconds it. Is there any opposed to it? Okay, so then I'm going to say, since there was no opposed, all in favor, say aye. Aye.
Aye.
Thank you. So the minutes pass. Okay, so the first order of business is the juror's oath. I'm going to pull that up and read it. It's on the screen before you. Tracy, since you're good at communicating, can you read that, or does it need bigger?
I blank give oath that I will and be and serve those of mankind in the office of juror, and will do right ruling by all manner of mankind, thereto witness a claim with facts and evidence to support said claim, and to render a verdict or uphold a verdict of a jury without fear or favor, affection or ill will, so help I, the existing one, God. That's the first paragraph. The blank is where the name goes. I blank give oath that I will and be true and will not knowingly take, directly or indirectly, any compensation for any matter done by me through virtue of my office, except through allowance made without effect to my verdict, and will not in any way show partiality or favoritism to anyone, so help I, with existing one God. That's the second paragraph. The third, I say here, semicolon, and will verify at open court, all be true by, colon, man or woman, semicolon, and then the blank for the name. Below that is the jurat for North Carolina or whatever county or nation state you may be in. I yield.
Okay. Yeah, that's, I don't know that we actually need that. Since we've discussed this before, I also, let me back up. The first paragraph where it says a verdict or uphold a verdict should say and or. Because basically the jury will render a verdict or just uphold the verdict of a claim. In other words, if there's no dispute, if whoever is making the claim, if there is no dispute to that claim and no evidence contrary to that claim, then it's really just to verify it. You don't actually render a verdict, you just verify that the claim has not been challenged, and so it's by default accepted. That actually could be handled by the magistrate without a jury, but because we're not confident that magistrates will do their job, that's the reason for having a jury of our peers. So Josh would make that one change there. And is there, the reason we put the existing one and God in parentheses is because God is an ambiguous statement. And so whoever would take the oath can say the name of their creator, whoever it is, if they wish, or they can sign it just as it is here. So, and then by having man or woman, they're just supposed to strike through which one it's not, or circle it just so that they acknowledge it, because this is common law. It is for men and women. It is not for persons. So with that, the jury doesn't need it. It could actually just be two witnesses that would witness that they took the oath. So I would like to ask for any comment on that subject. One way or the other.
I think it's good as read, there's that one change.
Just leave a notary on it, or go to just two witnesses?
Two witnesses.
I think common law needs to be two witnesses. So I was told that the notary was created by the Vatican at some point in history, and it does tend to grant jurisdiction. And from the scripture says that where two witnesses agree, a thing is confirmed. So as people who know that they are sovereign, you know, we're the ruler of ourselves, and we have no subjects. All we require is that it be that we have proper witnesses, and two witnesses would take care of it. Tracy, I value your opinion. Would you be willing to give your opinion on that? Either way, doesn't matter to me. I want to see what everybody thinks.
Sure. The notary public is public. It's not private. It's not sovereign. It is part of government. They're licensed. They're commissioned, so on and so forth. The witness is the correct way. There's another way to do it, but it's called a public notary, and it's a private notarized, private person who notarizes, which that's neither here nor there. You can just leave that out of the conversation. But from my understanding, yes, what you said is that the notary public was created out of Rome back in the day so they could steal some stuff. You know, it's
Yeah.
same old SSDD, so to speak. But yeah, the two witnesses, 2 to 3 witnesses, that's biblical. I yield.
Okay. So, Katie, what's your input? We lost Yvonne and them.
We're still here.
We're still here.
You are? How come they're not showing up on my screen?
They made me call in. I don't know why. They made me call in once I logged in on my phone. So maybe that's why.
Really? But I don't even see, I see Katie. I see her phone number up here.
It's showing 7 attendees and I can only see 6.
Yeah, so that's weird.
I can see all 7.
You can? Okay. All right, I'm not gonna sweat it, I can hear it, that's the main thing. Okay, so, well, since I'm hearing Yvonne and Jeremy, do y'all have any input? Y'all agree I should just go with 2 witnesses, 2 or 3 witnesses? Okay, Mary's back, but she's not showing up.
We put her in.
Did you see her come in?
I don't know.
Folks, we're having a little bit of technical difficulty here for some reason. I'm seeing people show up and they're not in the room. Okay, well, there's Yvonne now. Yvonne, did you and Jeremy understand the question? About the notary versus the, just the witnesses?
Can you hear me?
Now I can hear you.
Okay, yeah, we said yeah, we do.
Okay, all right. And Katie, did I ask you already and I've already forgotten? Okay, so I'm gonna,
Did you
say
hear me,
that,
McWick?
yes, now I can hear you, yes. Mhm.
Okay, I said yes. I think you should go ahead with them.
Okay, all right.
Witnesses.
So, then I'm gonna ask for a motion that we, make it and or, instead of just or, and that we remove the jurat, which is a notary process, and just put 2 witnesses. Can I have someone make that motion?
Yeah, I'll make it.
I was gonna let, somebody else, just so it's not always the same thing.
Yes, Wick.
Okay, that was Don McLean, he made the motion, second.
This is Jeremy, I'll second that.
Jeremy, Denault, right, seconds it. Okay, so now we're gonna go to the, magistrates, oath.
I have a question for you.
Yes.
We're going, once we've made those changes, we're accepting the oath as read otherwise, right?
Yes.
Okay.
No, excuse me, I'm still getting ahead of myself. Y'all forgive me, these procedures are not my, best trait. Matter of fact, I struggle to get through them. Okay, so, now that we've got a motion and a second, all in favor say aye. Aye.
Here.
Aye.
Okay, any opposed? All right, there's no opposition, so the motion passes that the oath will be accepted as read, with the exception of putting a and a / or, where it says or in the first paragraph, and then removing the notary process of authenticating the oath and having just 2 witnesses. Now the magistrate's order, oath, excuse me, not order. I'll read that. It's probably going to be basically about the same thing. It says, I, give their name, give oath that I will and be true and serve those of mankind in the office of magistrate, and will do right ruling by all manner of mankind, there to witness a claim with facts and evidence to support said claim, and to render a verdict and or, that's going to be the change, uphold a verdict of a jury without fear or favor, affection or ill will, so help I the existing one. And then I state their name, give oath that I will and be true and will not knowingly take directly or indirectly any compensation for any matter done by me through virtue of my office, except through allowance made without effect to my verdict, and will not in any way show partiality or favoritism to anyone, so help I the existing one. I say here and will verify at open court all be true by man or woman and their name. And then, of course, we would keep it consistent, so we would get rid of the notary and add 2 witnesses. Are there any questions?
Yeah, does the blank spot that we currently have with writing their name in the blank spot count as their signature, or do we need to add a spot for them to sign underneath?
No, there's a place to sign relief. That's the bottom blank.
Okay.
The I blank is just putting your name, and then at the very bottom, under the 3rd paragraph, would be where they would sign. We could add by, but if we do, we need to go back and amend the jurors. Hold on a second. Let me pull. Yeah, I tell you what. Let's if it's okay for the record, let's go back and amend the jurors oath, and on the autograph line, we'll put by colon, and then they autograph it. Is there any discussion about that? Okay, so
we have a bias. Now that I'm looking at it, if you look on the document right before you select man or woman, that technically would be what you're referring to. Maybe we just put that on an enter and make it a new line.
okay, we'll move it. We'll move that down
Okay.
and make the line go over. Okay, who made that motion
You can put it as you.
on the jurors? That was Don.
Yeah.
Don, are you okay to modify your motion for the record to move the by colon man / woman semicolon down to the signature line or autograph line? Okay, and then Jeremy, your second, are you okay with that as well?
Yes, I'm okay with that.
Okay, so all that were in favor, I'm just going to ask if anybody opposes to that. Speak now, forever hold your peace. Okay, that modification will apply to the juror's oath. And now I'm looking for a motion to accept the magistrate's oath with those same changes.
Yes.
Thanks, Don. Yeah.
So moved.
So moved. Who said that?
Tracy.
Tracy. Okay, so Tracy's gonna make a motion to accept the magistrate's oath as stated. Do I have a second? Okay, Don seconds it. Don McLean seconds it. All in favor, say aye. Aye. Any opposed? Okay. The magistrate's oath is passed. Okay, so now we're going to do the court requirements. So actually called court rules and requirements. Okay, so I'm going to start reading it for everybody, and I'll go slow, and I'm going to stop at each after each paragraph to see if anybody has any questions. It says, notice requirements of court. We propose that these provisions be made to stand in effect. For the purpose of this notice, the terms we, us, our, man, woman, men, women, and the like refer to the man's and or woman's pressing a claim in a court of common law as well as the singular includes the plural and the plural includes the singular, as well as terms are gender neutral. Anyone have any questions about that? Okay, the next paragraph. We, men and women, say that when it comes time for us, when those of mankind of a society not belonging to us do trespass upon us, and so comes a time for us to be present simply as a man / woman in honor, to seek remedy at the court, to open a case, to press a claim of trespass between us and man or woman of those of mankind, man and womankind, whom we believe have done a trespass to us. Is there any questions with that paragraph? Okay, next paragraph. We believe there are many types of courts on these lands under many different rules, codes, acts, and statutes, but few operate under law. So, to be clear, we will not appear or represent or pro se or diminish the status of ourselves to any other title, such as citizen, human, pro se, person, living beneficiary, free man on the land, sovereign citizen, trustee, executor, name, plaintiff, defendant, or prosecutor, and the like. Again, as it is fair to warn, let it be known, we will only be present at court as a man, woman. We will be present as a man to press a claim. Is there any questions, comments with that paragraph? Okay, the next section is requirements. We require a room to move this case at this courthouse, and we have chosen to be present before the court of record under oath to testify to what is true with facts to support a claim of trespass. We require to stand as a man who presses a claim of trespass. We require no legal advice, no legal forms. We desire not to be part of the bar association. We require a man or woman who will act as a magistrate to give their oath to the following before us at the court. We require a court of record for this court to be announced. We require any man and or woman invited to this court to do so under oath to testify to what is true under penalty of perjury. We require the court not to accept any legal arguments, codes, acts, or statutes. This is a court of law. We require the court will only accept claims with facts and evidence to support any and all claims. Number 9, we require the court to be private. Number 10, we require all orders by the court to be carried out within 21 days of verdict. I'm going to stop there. Any comments, questions, concerns for those 10 requirements? Okay. Yep.
Wick, under number 2, didn't that say A man and B woman?
We require to stand as a man. Okay. How about / woman? Or just or woman? We'll do or woman. Right? Yep. Okay. Okay, so good point. Number 2 will now read, we require to stand as a man, or woman who presses a claim of trespass. All right. Thank you, Tracy. Next paragraph after number 10. We say, we as man, woman, will be present to hear any man or woman with verifiable claim of wrong, debt, and or trespass of us to testify under oath as to how we have done them wrong and to offer remedy. Any questions on that one? Next paragraph, we say, if no man or woman brings forth verifiable claim, then we will be present to press a claim of ourselves under oath at the court. Any questions? Okay. Next paragraph, we say if there is a legal complaint and or motion on the days or date of this hearing, and as those who are mentioned in our claims will be present on said day, we will simply press this claim of trespass on the same day for the convenience of the court, for the magistrate to verify said claim or schedule a future date for trial by jury to consider all claims, complaints, and or motions set before said jury and to render a verdict. Any questions on that one? Because that's got a little bit of stuff in it. Okay, next paragraph. We say if the man or woman is invited before this court for trespass and does not have a lawful excuse as to the why of such trespass or claims of contrary, and the man or woman acting as magistrate and or jury has now the findings of facts and conclusions of law on the record to make a verdict in favor of us men, we probably should say men and women, or women, men, whom now press this claim, then the orders of the court are to be enforced, and the orders we present to said court are to be rendered to the clerk of court, and his final verdict and court seal rendered. That needs something. Somebody help me out. To be affixed.
Can you read it again?
It says, we say if the man or woman is invited before this court for trespass and does not have a lawful excuse as to the why of such trespass or claims of contrary, and the man or woman acting as magistrate and or jury has now the findings of fact, the conclusions of law on the record to make a verdict in favor of us, men and or women, whom now press this claim, then the orders of the court are to be enforced, and the orders we present to said court are to be rendered to the clerk of court with his final verdict and court seal. I guess that's...
It reads okay. I think you're just meant to be a period there.
Okay. Yeah, little period there. All right, any questions? Joshua said it seemed to be fine. Just put a period at the end. Most of them have a semicolon because it's all one process, except the next one. Okay, this one might be a issue, but we'll see. We say the orders are binding and should be notarized. Semicolon.
So I'm curious, should we change that to have to do with witnesses now, or taking other things in that direction as well?
Well, the thing that we're dealing with now is that we're dealing with a court that does operate in the public,
Right.
to carry out the order. So I'm interested to see what Tracy and Yvonne, Jeremy, any of those might have to say. That would probably need to be notarized so that the de facto authorities will carry it out. But what do y'all think? Floor's open for questions and comments.
I guess, how can you accept notarizing for one thing and not for another?
That's a thought. Basically, my only thought on it would be that up to this point, this is dealing with men or women, and it's the private method. But once it has to go to court, it becomes a public issue to be able to get a judgment, or a verdict. Go ahead.
Maybe we could step in and say this should be notarized. I don't know how you would word it, to observe the public rules, I guess.
Public notary.
Tracy, you have any comment?
Yeah. If you're bringing this in front of a public magistrate, then your notary would be appropriate.
Public notary.
You know, our goal is to set up either courts of equity or courts of common law. And that's American common law, it's not English common law, because English
Right.
common law is technically merchant common law. The only thing I can tell you, you know, is like I said before, if you're gonna bring this, if you're gonna bring this in front of a either elected or appointed public magistrate in the de facto, then probably the jurat would be appropriate. I yield.
Okay, so, no, what I hear, I'm saying we just leave it. Because I see, here's what I see, and that is that a process is taking place. And then once that process is taking place, then it has to change to another process for collection. Kind of the same as if you settle the matter between yourself. Well, if a guy pulls out his checkbook and writes you a check, then you don't need anything. But if he doesn't, then we have to have a way to enforce it, and that would be the purpose of having it notarized.
Makes sense.
So, again, I'm limited. This is just what we're gonna go with unless somebody can tell me differently. Okay, so next paragraph.
wait.
You,
I got a question for you.
all right.
Paragraph where the final line says, with this final verdict in court, it
Right.
to be rendered to the clerk of court as final order. I had it in my mind a minute ago. You know the documents that I've been getting.
Yeah,
It is signed by a judge and this day so ordered and sealed by the court and sent to be enforced. Once it hits a court order, then it moves from there to whoever for them to enforce that. That's just a question.
floor is open if anybody wants to make a comment.
Is the question about enforcement concerning once the order from the de facto court has been issued, where does that go to for enforcement? Is that what I'm hearing you say?
Pretty much, I said, I'm going back from an old line that I remember years ago. So it is said, so it is written, so it shall be done.
Uh-huh.
Well, that would be on the verdict or the order.
Okay. All right.
Yeah, because it says in the line above it, they are to be enforced, and the orders we present to said court. So the order would have the verbiage on it that you're talking about. But what makes it authenticated is to have the clerk's court seal on it.
Okay.
That's the main thing. I think it is.
That's correct.
All right. Because the clerk is the keeper of the court documents, and so the court clerk verifies that it is true.
Okay.
All right, going to the next paragraph. We say it is fair to warn if the man or woman believes it is not proper to proceed in this lawful manner, then the court wishes to have findings of fact and conclusions of law on the record in order to prevent a trespass on this case. That's for all those bar attorneys to say there's no basis for this in law. Any questions with that statement? Okay, so then next paragraph, we say and do and will verify all herein be true at open court on the public record, and to whom all it may concern by our autographs fixed to this notice, the men and women who do claim, and then autographs. Any questions there? All right.
One,
Yes.
who are we looking to get to sign this? Is this just a handful of people to imply that this is the...
Basically, what I'm planning to do is the ones who are here present will autograph it. If everybody who's on here can send your address, the mailing address to Watchman, the Watchman email address, then we will actually circulate this document, have each of you autograph it, and then return it. And we can do that. We can have the envelopes in there that will you won't have to pay any postage on it. So, does that make sense? And with that, I don't know about page 3 that has the jurat on it. I don't really know that we would need to have that if we have, 8 autographs on the document itself. It's kind of like the Declaration of Independence didn't have a notary on it. When you got that many people autographing it, because the process, what we're going to do when we finish this is we're going to put it back in the paper again. We're going to ask in the legal section, and we'll ask, is there any, was the notice contested? We're going to record it being read from the courthouse steps, same day, same time, 3 weeks in a row. And then we'll probably put it in the paper so that when we present it to the court clerk, there won't be any excuse that anybody can come up with legally or lawfully that it's not a valid process. Because that's basically what they do. They'll post something outside the courthouse, a public notice, and on the clerk's board, and it is what it is, and we'll record it with the county. Now, that's just my thoughts, based on what I've gleaned from listening to other people and even the court clerk tell me how they do stuff. And so is there any discussion? Okay, so I'm going to ask for a motion that we accept the court rules and requirements as read with the changes, which includes removing the third page with the jurat. Do I have?
I have
Okay.
one question before we
All right.
go through that motion.
Yep.
On the last sentence of that one, with this final verdict and court seal, is there a difference between orders and a verdict?
Which one are we talking about?
I'm getting at, should it say with this final binding verdict and court seal? So it holds those two together, orders and the verdict, that are both binding?
Okay, so with his final order, you're breaking up. Try it
No,
again.
just one second.
I may know the answer to this one too, is the difference between the two. The verdict would then the verdict is the content and the order is the issuance that you need to follow this
Right.
judgment, basically, right?
Yeah. A verdict is rendered by a jury.
Okay,
Okay,
then should we, is the word "is" the correct word?
that is probably correct that you are wrong. I mean, you are probably correct that that is not a correct word, except because, well, it's gender neutral. So really his is her, and that would depend on whether the clerk is a man or a woman. So it's basically, it's rendered to the clerk of court with his final, I see. Should it say final order of the verdict and court seal?
Or maybe just change it to
I don't know
the
what
final
you're
verdict.
We want to tie the word verdict and make sure that order is.
Okay, so Joshua said let's change his to the. With the final verdict and court seal. How about with the final verdict and court seal on the order?
That's better. Because when you say his, it's the jury's, isn't it the jury's verdict?
Yeah.
Yeah.
Okay.
There's one person.
So if you put the in front of it, then it's not gender specific, or it's specific to the verdict, whatever that verdict is.
Yeah. Okay. So let me read that one more time. I'm trying to figure out where to start reading it from.
You can start with the order of the court.
With the final one.
I'm going to start, are to be enforced, and the orders we present to said court are to be rendered to the clerk of court with the final verdict and court seal on the order, placed on the order. Does that sound good?
Yeah.
No, how about seal to be fixed?
How about a fixed seal?
All right, here's what I did. See what you think. We present to said court are to be rendered to the clerk of court with the final verdict and court seal to be fixed to the order.
I think it reads better.
I don't think you need to the order. I think you just need a fixed, because you just said seal and verdict.
Well, the reason is we don't have the order there, and the order is what carries it out. And you shouldn't say affixed, even though that's a word we use, because that means no fixed in syntax grammar. So I try to eliminate some of that stuff when I know it's obvious.
Okay.
So that's just my faults.
This is Tracy, may I?
You sure can.
The verdict comes from the jury, the order comes from the magistrate or the court.
Correct.
So you're going to have to include the order and the verdict. That's what I'd say. And that's my comment. I yield.
Okay, so was my verbiage correct? And it says with the final verdict and court seal to be fixed to the order?
I believe so, yes.
Okay, all right. Then I'm good with that if everybody else is good with that. So do I have a motion to accept the court rules as modified?
Tyrell, yay.
Okay, Tyrell Jones has made a motion. Do I have a second?
Second.
That was Tracy. Second. All in favor, say. Oh,
I have a question.
all right. Yep.
Okay, we want to make sure that the verdict is binding and that the order is binding, do we not?
Yes.
If verdict if we just say the final verdict, and then the magistrate could come and change it because we didn't say that verdict was binding, and he can change that order to what he determined as binding, can he not?
All right, so should we say comma and binding on all parties?
Yes.
With, or just say with the final binding verdict. So then they're both binding.
Final binding verdict?
With the final binding verdict.
Okay. Okay.
At least make it harder for them to change the verdict, I would think.
I would go with binding on all parties. That stops.
Final binding verdict on all parties, that's what you're saying?
Yes. If you do that, that stops everybody.
Yeah.
Okay, so we're saying to have binding in there twice?
Well, yeah, because one's a verdict and one's the order, right? One's to fulfill the order of the final binding verdict.
Okay.
Well, I will point out though that the next line does imply that the orders are binding, so all we need to focus on in this one is.
Oh, yeah. The next line shows that the orders are binding.
So, yeah, just fix the verbiage.
I'm trying to say, are these two separate things? Because one is by the juror, the verdict, final binding verdict of the jury, and if one is to the magistrate, we want to make sure that the magistrate can't change what the jury.
Right. Okay.
In other words, he thinks if he determines on his own unilaterally that the verdict is too harsh or too lenient or whatever.
Well, we'll remind him of his oath. He doesn't have that leeway. He can only render the verdict by the jury. So, but here's how I changed it, and let's see if that works for everybody. I'm going to start a couple lines up. For the men and women who now press this claim, then the orders of the court are to be enforced, and the orders we present to said court are to be rendered to the clerk of court with the final binding verdict and court seal to be affixed to the order and binding on all parties.
Yes.
Okay. All right.
Or I don't mean to confuse it, but or you could have said are to be binding up there instead of rec, right?
Where did you say that?
We present to said court are to be binding.
Well, the rendered means it's supposed to be given over to the clerk. So that would be a proper place.
Yeah, I think that was the way you got it. That looks good.
Okay.
Okay.
All right, so I'm going to read it again. Let's see if we're okay with it. Men and or women who now press this claim, then the orders of the court are to be enforced, and the orders we present to said court are to be rendered to the clerk of court with the final binding verdict and court seal to be fixed to the order and binding on all parties. Okay, so do we have a motion?
I'll make that motion that we.
Okay, Tracy makes the motion to accept the court requirements and rules as read and amended. Do I have a second?
This is Jeremy, I'll second that.
Jeremy seconds. All in favor say aye. Aye?
Tyrell Jones, aye.
Okay. Any opposed? Okay, so the court rules and requirements have passed. Now, at this time, I'd like to open the floor to select jurors. Basically, we will have to keep doing this until we can get, I think we should have 24. You're supposed to have 12 jurors and 1 alternate, but because we're, as we are, we would need to have probably more to be safe. Do I have a motion from the floor that we select jurors at this time? I'm hearing some noise, but no.
So moved.
Okay, so Tracy makes a motion to begin the selection of jurors. Is there any, is there a second? Second from the floor from Joshua Hollenbeck. All in favor, say aye. Aye. Any opposed? Okay. So I'm going to nominate Tracy to be a juror. Is there a second?
Second.
Okay, that was seconded by Don McLean. All in favor, say aye. Aye. Any opposed? Any opposed? Okay, there's no opposed, so Tracy is the juror. I also have a online candidate who could not be here. It is John Keister. That name is spelled Kistler. He said he would be happy to be a juror, so I'm going to nominate him at this time. Is there a second?
Second.
Tracy seconds it. Is all in favor say aye? Aye. Any opposed? Okay, so John Keister is a juror.
I'd like to nominate Yvonne.
Okay, Tracy has nominated Yvonne Denault as a juror. Is there a second?
Can I ask a question?
Yes, you can.
Time frame. I know you probably don't have dates of anything yet. My fear is that I have a bunch of prior appointments with my clients.
That's the reason. That's the reason it would be done far in advance. It'll be more than 30 days or 45 days before we would actually go to court. Yeah, and that's the reason we're having alternates, because there's no telling what's going to happen between now and then. So, yeah, you won't be held in contempt of court if you can't make it. So, I might call crying and say all I done to help you and you can't come. No. So with that, we have a motion for Yvonne and a second. Do we have a second?
Second.
Jenny Mixer has seconded it. All in favor say aye. Aye. Any opposed? Okay, so we're good there. All right. Also have another absentee that has offered. That's Richard Howell. Richard Howell, I'm going to make a motion to accept Richard Howell as a juror. Is there a second?
Second.
Josh? Okay, Tracy seconds it. All in favor say aye. Aye. Any opposed? There's no opposition, so Richard Howell is a juror. Next nominee is?
How about Don?
Don McLean. All right, is there a second?
Who nominated him?
Tracy nominated Don McLean. Jenny Mixer has seconded that. All in favor say aye. Aye. Any opposed? There's no opposition, so Don McLean is a juror. Next nominee.
Jeremy?
Nominate,
Okay, so who nominated Jeremy? Yvonne nominates Jeremy Denault. Second.
second?
All right, Tracy seconds it. All in favor say aye. Aye.
Aye.
Any opposition? No opposition.
I nominate Wick.
Okay, I accept. Who seconds it?
Who was that, Tracy?
Tracy nominated me. Joshua Hollenbeck seconds it. All in favor say aye.
Aye.
Aye. Any opposed? No opposition? Okay.
I nominate Dante.
Jenny Mixer nominates Dante Emmons. I'll second that. All in favor say aye.
Aye.
Aye. Any opposing? No opposing? He passes. I'll nominate Tyrone Jones. Is there a second? Okay, Tracy seconds it. All in favor say aye.
Aye.
Aye. Any opposed? Opposition? None?
Nominated for juror?
Yeah, for juror.
I accept.
Okay, so, who we got left here? Katie, just a second here.
Who's Jenny?
Jenny Mixer?
There's a missing link.
Yep, there you go. All right, somebody nominate her.
Who is it?
Yeah, she's nominated.
Tracy nominated Jenny Mixer. Don McLean seconds it. All in favor say aye.
Aye.
Any opposed? No. All right, she
I
passes.
nominate.
All right, Jenny Mixer nominates Joshua Hollenbeck.
Second?
Tracy seconds it. All in favor say aye. Aye.
Aye.
Any opposed? Nope. Okay, Joshua Hollenbeck passes. I'm going to mute myself just a second like a phone call. Do we have anybody else?
Not present.
Is there anyone on the call that hasn't been nominated? Please speak and step forward.
I don't believe there is.
Is that, who was that? Mary?
She's not on there. That's why I'm going to call her in just a second. How many do we have?
11.
11? Okay, so at this time, is there any discussion? We're probably going to have to adjourn and have a future meeting and reach out to people to participate. Unless anybody's got it. Yeah, Tracy, go ahead.
Okay, so on the notice for the meeting, I see a fairly substantial list. I know people don't always attend, but you have an email list to reach out to.
Yep.
And if you could reach out to those people via email and see if they're willing to stand in the jury. If you get responses at your next meeting, you could kind of have a mass swearing, if you will. You could, read off the names that are willing to stand as jurors and then make a motion to accept them all. I yield.
Okay. Do you have his email address, Tracy?
Yes.
Yeah, okay, gotcha. Well, the exciting thing is that we actually have 11 selected, and so I plan to have that in an email to people actually see that it's being done. I got a feeling that, like so many things, people see stuff and they just kind of discount it and don't consider it to have any valid effect, or they wait to see if it succeeds. The only problem with things in life, if you ever wait on somebody else to get it accomplished, nobody gets anything accomplished. So I agree with you. We can have a mass swearing in because we can do it digitally, and we can have hopefully get it accomplished. So with that said, I'm going to say we adjourn until 2 weeks from today. Does that work for everybody? That will be the 15th, and it'll be 3 o'clock because we do know that the Eastern Standard Time, because the shelters rent at, I think, 2-hour increments, so 2 to 5. Can I get a motion from the floor that we adjourn until 3 o'clock? 2 weeks from today.
Motion.
All right, Joshua Hollenbeck makes a motion that we adjourn until May the 15th at 3 p.m. Eastern Standard Time. Can I have a second?
Second?
Second by Tracy. And all in favor say aye. Aye. Any opposed? Okay, thank you. Y'all have a wonderful day, and thank you so much for participating and trying to bring freedom to everybody. We'll end the meeting.